You say that getting a birth certificate authenticated means you are the actual owner. That is not what authentication means. Yeah, authentication is an evidentiary rule. You have evidence that is considered self-authenticating, and you have the types of evidence that needs to be authenticated. Authentication means may be defined as the act of giving legal authority to a written instrument or certified copy thereof so as to render it a legally admissible into evidence. Authentication is simply a process to establish the relevancy of a document by connecting it with a person, place, or thing. So authentication is just something that you're doing to have the court take notice of it and treat it as if it is the record, not that it is. See, that's the problem. And that's what people are not thinking about. Authentication for purposes of admitting a document into evidence requires merely a prima facie showing that the evidence is what the proponent purports it to be. A prima facie showing. Well, one, you have no firsthand knowledge of what that record is. You're making a presumption. Vital records will never even give you the record. They just are telling you that, hey, here's the certificate of live birth, and they are purporting what it claims to be. Now, let's look at this case out of North Carolina. This is called State v. Gray. Right here, criminal law. So-called certificate of birth was purported to be an original document which, over signature of a deputy registrar, merely summarizes certain information. So, a certificate of live birth is only a summary of what's in the record. Recorded at the Office of Vital Statistics in the county on a certain birth certificate was no more than the deputy registrar's assertion of what she found. That is not first-hand knowledge. On recorded birth certificate, and as such, it was double hearsay and inadmissible. See, it's double hearsay because they have no first-hand knowledge. And that is the holding of the court, one of the holdings. It says that right here. It would have been, however, a proper ground of objection. You can pause it and read it. So the certificate of live birth and the birth certificate are considered double hearsay. And you got to think about it. That's logical. Because I very seriously doubt there's any state witnesses that can testify. Oh, I was there. I watched them. That would be kind of creepy, wouldn't it? Now, and if you think for a second, that's the only case that says this. Let me show you some more documents. Names, generally, definition of name. Look right here. Documents such as a driver's license do not determine what constitutes a person's legal name. Now, before anybody wants to gloss over that, it's also talking about the birth certificate. I'll show you. This is a bankruptcy case. See, the first case I showed you was in North Carolina. The second case is in United States Bankruptcy Court, Massachusetts Western Division, right here in paragraph 8. And that links up to a footnote, by the way up here. Under Massachusetts law, documents such as a driver's license do not determine what constitutes a person's legal name. So let's go back down. Let's look at it. Now, Supreme Judicial Court is also called the SJC, just so you know. For example, in Clark, starting right here, for example, in Clark, the SJC noted that even the name on an individual's birth certificate may not be the individual's true name under Massachusetts law in light of the common law rule. In the Secretary of the Commonwealth versus City of Clark of Lowell, the SJC took care to clarify that to the extent any of its earlier cases had suggested that a person has a legal name or a name with legal effect different from the name he has lawfully chosen, those suggestions were not necessary to decision. When have you chosen who you are? See, you're using state-owned property to claim who you are. You don't even know what that record is. You don't know what's in the record. You're making a presumption of what's in the record. You have no firsthand knowledge of what's in the record. It's all presumption because you don't remember coming out of your mother and saying, "Hey, Mom, I'm here. Can I witness anything?" See, there's a lot of laws at play here. And one, that you're violating. Property rights. Property rights goes to the owner. How are you the owner? And if you don't know what's in the record and you're authenticating it, what are you authenticating? Ask Vital Records to ask for a copy of the underlying record. They'll never give it to you. And they don't have to because it's theirs. See, I understand we love our moms. And I understand people run around thinking, because it's my name, that you believe you have to authenticate it to have some kind of power. No, you don't. It is what it is, not what we think it is. So let's listen to what Vital Records says in their own words. Right, here's a video I made. It's 17 minutes long on my channel. It's titled, Who Owns It? Let's see. Whose property is it? It's not yours, nor is it you. And some of y'all remember what Jake Ehrlich and Johnny Carson, the conversation they had. You can go back to that. Listen to this.
Let me ask you a question. What is your name? What is your name?
I refuse to answer. No. My name is Johnny Carson.
How do you know that to be your name?
Well, it's on a birth certificate, legally
That's
recorded.
hearsay.
That's hearsay?
Well, of course.
Well, I mean, if it's legally recorded?
That's still hearsay. Suppose you were born, and I must assume that you were born because you're here tonight with us. There's a certificate made out not by you, certificate made out by somebody else, that a boy child was born to Mr. and Mrs. Carson, and that he was named Johnny. That doesn't mean that you know that to be the fact. That means you have read that to be the fact.
Okay, so who owns the record then?
The state of North Carolina, or whatever state that you were born.
So the state of North Carolina owns the record. Okay. That explains a little bit. They tell you in their own words that they own it. Shoot, Pennsylvania has a law in place. You can't get a copy of the actual record after the first year the event happened for 105 years. And they tell you the reason why is because of privacy. But wait a minute. I thought you said it was your record. See, yours imply ownership. But you personally can go in there and request what you think of as your file. It's not yours. Now, let's listen to what they say here. Now, I want you to pay close attention to this next part. See, when something dies, it is placed into probate. You're not dead. Now, can you tell me when the probate file was recorded?
No, sir.
But there is a probate file.
So if you want to do, so we, as I said, we don't get into a lot of information because it's not public. A lot of this is not public record, not for the customers.
Okay.
It's just certain things we can,
So wait a minute. There's a probate file. Now, why would vital records not get into that? So now let's look at this right here. This is authenticated U.S. government information, top left corner. Public Law 107-207, passed by the 107th Congress. This is a recent addition. This is not when it first began. They made an amendment. The act may be cited as the Born Alive Infants Protection Act. The word born alive is a legal term. You'll see it as live-born, live-birth, or born-alive. It's a legal term. I'll show you the definition of the legal term here in a moment. And see, this is the federal law. And it is worded out very close to the same thing in almost every state. Paragraph B. As used in this term, the term born alive with respect to a member of the species Homo sapiens means the complete expulsion or extraction from his or her mother of that member at any stage of development who, after such expulsion or extraction, breathes or has a beating heart, pulsation of the umbilical cord, or definite movement of voluntary muscles, regardless of whether the umbilical cord has been cut, and regardless of whether the expulsion or extraction occurs as a result of natural or induced labor, cesarean sections, or induced abortion. Let's look at a state record. Go down to page 6. I like this one. Live birth is defined. There's that phrase. Live birth is defined as the complete expulsion or extraction from its mother of a product of conception, irrespective of the duration of pregnancy, which after such separation breathes or shows any other evidence of life, such as beating of the heart, pulsation of the umbilical cord, or definite movement of voluntary muscles, whether or not the umbilical cord has been cut or the placenta is attached. There's a definition of live birth. Each product of such a birth is considered live born. How many products are there? How many products? And which one got named? See, that's the question you don't know. Well, the mother's intent. Well, that may be true. That may have been her intent, but guess what? The mother technically is legally incompetent during the process because she's under the care of another. The only competent person that could declare anything is the father. But the father never did it. Now, here's the definition of born alive test. A showing that an infant at the time of birth was capable of living a separate and independent existence, regardless of how long the infant actually lived. This test was first announced in Bondbreast versus Coates in 1946. So, the mother gives the infant to the hospital, and I've had ladies say, but we took our placenta home. Yeah, under the title of custodian after the assignment was given. Here's a contract we found about 5 years ago. Now, this is just one piece of evidence. There's a lot more. I got a longer video that goes over all the different documents. But authorization and assignment, what's it for? For care. This authorization and assignment is a permanent one-time signature which will remain on file and will be used for future claims. I may revoke it at any time by written notice. And you talk about them violating HIPAA. A lot of times they're not violating HIPAA. You gave them permission to do everything. The mother did, not the father. Okay? What's an assignment? Assignment, the transfer of rights or property. Assignment of stock options. Why is that important? Let's look at something else. The fourth definition applies in this situation. Look at number 4, a document in which a fact is formally attested. Well, if you don't know what the fact is, how can you attest to anything? But then it gives an example, death certificate. Who keeps up with death certificate? Vital records. What else do they keep up with? Marriage certificates, birth certificates. And then it says afterwards, see stock certificate. Just saying. So the mother, before the birth event ever happens, gives an assignment to the hospital. Information reported by a person who assumes the custody of a live-born infant of unknown parentage. Says it's supposed to report it within 5 days. What does it say in B? Sex and approximate birth date of child. So you're even presuming what the birth date is. Because it says birth date on it, that's an approximation. Why? It's hearsay. They have no first-hand knowledge. Name and address of the person or institution with which the child has been placed for care. That's the hospital. D. Name given to the child by the custodian of the child. It don't say mother. The mother puts on the legal hat of custodian because she signed a contract giving assignment to the hospital over the infant, not the baby. See, we're a bunch of narcissists thinking it's all about us. And if the birth certificate went into probate, that makes the state the grantor of the trust. Social Security trustees are known, and the state's the beneficiary of the trust, but you're volunteering into servitude, accepting all the liability. I could put out a lot more information, but you get the idea. So you're authenticating a birth certificate. What are you authenticating? You don't even know. You're making presumptions about the record. And all of this is in their own words. Take it for whatever you will.